Hey everybody, this is attorney Andy Marcantel and attorney Marc J. Victor, and we are the partners at the Attorneys for Freedom Law Firm here today to talk about, Marc, I figured we'd take on just a really easy, light subject of abortion in light of this recent leak from the United States Supreme Court. What do you think, man?
Let's try to make it as simple as possible.
Right. Okay. Well, how do you want to start? I think maybe we should start about talking about the leak itself and how, frankly, unprecedented this is.
Yeah, I think that's a reasonable place to start. Wow, this was out. When I first heard about this leak of a draft opinion from the United States Supreme Court, I didn't believe it. I thought it was just somebody was scamming me or something, because this is unprecedented. There has never been a draft opinion from the United States Supreme Court that's ever been leaked.
Even learning what the deliberations are of the justices involved ahead of time and hearing rumors about so-and-so might vote this way or that way is extremely, extremely rare. So, yeah, a draft opinion being leaked to the public, unheard of.
Yeah, this is just one of those things where institutional norms are just being torn down and destroyed left and right. This is the one branch, the third branch of government, Article 3, in the United States Constitution, that is supposed to be outside of political influences. That's exactly the way the framers of the Constitution wanted this. That's why they're appointed for life. Yes, they've got to be appointed by the president and confirmed by the Senate. That's the political process. But once they're on the court, what we want them doing is legal jurisprudence. We don't want them catering to public
social pressures,
right,
the politics of the day and what the parties are saying and everything like that.
Yeah, this was a disgraceful violation of trust by somebody over there, and I'd be shocked if it was one of the justices. I'm sure it wasn't. But whoever it was, I think there's going to be a real question about whether this is a criminal act or not. This has not occurred before, so we don't know. But in any event,
now, of course, right now, about half of the country is calling for charges and investigation against this person, while the other half are maybe hailing that person as a hero. And surprise, surprise, that line is divided pretty clearly right down party lines.
Yeah, we need to step back from that. And we need to say, look, as Americans, we need to all be unified around a position that the Supreme Court acts differently than the other two branches. Everybody should be outraged by this leak.
Yeah, absolutely. And so the rumors are that this is a clerk of one of the justices. That has not been confirmed. But for whatever reason and whatever means, the opinion has been leaked. It is written by Justice Alito. It is in the Dobbs case. The name of the full case is Dobbs v. Jackson Women's Health Organization. It's a case out of Mississippi where they're challenging a law that was put in place called the Gestational Age Act, and that law makes it illegal to have an abortion procedure, to perform one or receive one anytime after 15 weeks. So the draft has been confirmed as authentic. A couple disclaimers there, though, that were present in the press release that occurred. So Chief Justice Roberts released a press release that confirmed the authenticity and expressed outrage about this. I can't believe this has happened. Public trust has been compromised in the Supreme Court process, and several of the justices took public positions that we're not going to let this in any way, shape, or form affect our decision-making. We will not cave to public pressure. We're going to do our jobs. They expressed concern about this type of behavior and it ever happening again and things like that. So another disclaimer that came out in the press release is Chief Justice Roberts said, "This is, however, just a draft. And right now, this does not represent the final decision by the court. This does not represent set in stone what every justice is going to be voting for. We can change our votes up to and including the day before the opinion is issued. So it's not necessarily the final word on this issue."
Yeah, and I was really happy to see the court take a position that, look, we're not going to be affected by pressure. It doesn't matter if people are out in front of the homes of the Supreme Court justices. It shouldn't, right? This has to be separate from political pressure. And yeah, it's a draft opinion. And, my guess is they're pretty far down the road by the time they're writing the draft opinion. But people can still change their minds, and so they probably won't. But we need to keep in mind that this is not the final opinion.
So let's have a quick segue here to how the public is responding to it, right? Because what I'm seeing right now is boo this opinion, it's horrible, abortion should be legal. Yay this opinion, abortion is evil, and we're happy that they're rolling it back. Or some version of yay this opinion because they're relegating it to the decision of the states. But what I'm not seeing a lot of, in fact, what I'm seeing almost nothing of, is, well, was the decision correctly decided? What was the legal reasoning behind it? Is Roe v. Wade ripe to be overturned? Was it a good decision originally? Was it a bad decision? A legal analysis, a cold, calculated legal analysis is, I couldn't find it barely anywhere in the media.
Yeah, all we got is people cheering for their teams, as usual. If you are on the pro-life side, then without even reading the decision, looking at the legal analysis,
you're like, yay, my team won a point.
And if you're on the pro-choice side, without looking at anything or thinking about anything, your position
is an outrage. It's the Handmaid's Tale made reality. This is, the crazy Republicans are coming for us and everything like that.
Yeah, and so I think we should probably, I hate to do this, but we should step back a little bit and talk about the structure of the Constitution. I think it's important just to get a little bit of background, to talk about the Constitution, and to talk about some of the earlier cases, specifically Roe and Casey, and then we get to this decision.
Well, why don't we start with the role of the judiciary and the other branches of government? Why don't we just start with the division of powers?
Yeah, this is a great idea, actually. So the framers of the Constitution and the founders of our country didn't trust the government. That's clear, right? They didn't, for good reason.
This is very well documented that our founders did not trust the government.
This is very clear, and with good reason, right? Government power is often abused, right? And so the idea here is, look, if we're going to have this government thing, let's divide the powers into three separate branches. And to be clear, it's all about the law. It's always been about the law, right? There's the first branch that makes the law, the legislative branch. That's Article 1 of the Constitution. Then there's the second branch, which is the branch that enforces the Constitution, the executive branch. And then there's the third branch, the branch that interprets the law. So there's the make the law branch, there's the enforce the law branch, there's the interpret the law branch. The idea here is that if we break them up and then we put checks and balances on each of these branches so they kind of keep each other in check, this will serve to keep government power in a box and make sure that they don't overrun our liberties. Well, it didn't work out so well.
No.
Didn't work out so well, but that was the idea. Stepping back from that, they said, look, in Article 1, specifically Section 8, these are the specifically limited delegated powers that we give to the Congress to make the law, and that's it. These are the only things they can do. We find things in there like the post office, coining money, declaring war, regulating interstate commerce, and I hate putting that one in there, but it's in there. And
the reason why Mark and I grumble about that, if you're not familiar with how the Commerce Clause has been twisted and warped and expanded to eat up all of your rights and allow the federal government to basically do anything it wants, that's an interesting history. Maybe we should do another video about that sometime. We should. That's it. It's what started as a very specific and limited power to regulate interstate commerce, which really meant to just make sure that the colonies had a free trade zone, right? To regulate, to make at that time meant to just make sure it was working well. That's all. And it's turned into anything that is remotely touching commerce in any way at all is subject to... Even incidentally. In the smallest ways possible now is within the jurisdiction of Congress to do something about. So then things get turned on their head with the Bill of Rights. I know everybody loves the Bill of Rights. So start with maybe the First Amendment, right? Basically saying, look, they can't take away, the Congress cannot take away your right to free speech. Well, to me, the proper objection there is, wait a second,
There's nothing listed in Article 1, Section 8 that says Congress has the power to take away speech. Why do we have to say in the First Amendment they can't take away speech or your right to exercise your religion, or in the Second Amendment they can't take away your right to keep and bear arms? Because we didn't give them that power in the first place. Now, that was an argument that was brought to say, look, we don't need the Bill of Rights.
We don't need it. And worst case, best case scenario, it's just superfluous. But worst case scenario, people might interpret this to mean that the government has the right to take away other things or grant other things.
Anything that's not listed. Hey, They didn't say that they couldn't take away your right to smoke marijuana, and therefore they must be able to regulate that. Well, so the compromise here to deal with this, I think, huge inconsistency to say, even to turn the entire concept of what they tried to accomplish with the Constitution, was to say, okay, look, let's just put the 9th Amendment in here to make it clear. Look,
good old number 9.
Just because we said there are all these rights in Amendments 1 through 8 doesn't mean there's not a bunch more unenumerated rights that we haven't listed, but you still have. There's a whole bunch of them in there, and we just want to be clear about that. How many have they found in the 9th Amendment, Andy?
Grand total of the goose egg. 0 rights have been interpreted from that catch-all provision.
That's right. And then, of course, there's the 10th, which reserves some other rights to the states or the people in the 10th Amendment. So that's kind of the structure of where we're at. And
so to recap, it seems they made it as confusing as possible.
They did.
So we have the Constitution that says the government can only do this. Then, to complicate matters, they list.
They say they can't do that. They can't do this.
They can't do this. They can't do this. They can't do this. Even though they've already said they can only do these things.
That's the problem.
And then to further complicate it, they add another amendment that says, "Oh yeah, by the way, there are certain things we're not mentioning here.
There's a whole bunch of other things they can't do.
There's a bunch of things that they can't do that we're not mentioning here, but it doesn't mean just because we're not mentioning that they can't do it."
Okay, so fast forward, right, to the cases on contraception, right? So the states say, look, we don't like this whole contraception thing. We don't like the fact that individuals are using contraception to not have babies.
Interesting little point here is that the Griswold case starts out with an analysis between married
That's right.
The use of married couples in contraception. They put it in a different analysis than people who are unmarried using contraception. But that's a side note.
And so we're talking about Griswold versus Connecticut, which was really a case where they kind of came up with a new right. They said, look, it's true you have a right to make decisions about contraception if you're married in the Griswold case. Later on, there was another case that said even if you're unmarried, you can make decisions. But where do they get that right? Where do people have a right to make decisions about contraception? Well, they sort of hinted in Griswold that, even though it doesn't say it anywhere in the Constitution, you have this right to privacy.
You said they kind of made it up. They completely invented it. They extrapolated. They listed the penumbras of various different amendments and took this and took this.
I got to say, though, I like a right to privacy.
Everybody should like a right to privacy. Everybody should love the thing that they created from that case that led to other things maybe that they also like. But let's stay in the cold legal analysis.
To be fair,
realm.
The word privacy is not in the United States Constitution. The Constitution doesn't say you have a right to privacy. It doesn't. The word's not even there.
They pulled it out of their butt, and then they extrapolated a whole bunch of other stuff, including what Roe v. Wade extrapolated.
Yeah, so then we get to Roe v. Wade in 1973, and many states have laws against abortion at that time, and the court comes down 7-2, and they basically say, we have that right to privacy. That's true. But part of that right to privacy or derived from that right to privacy is a right to have an abortion, at least to be free from excessive government interference. Because to be fair, no right is unlimited, right? I mean, we had the Heller case in 2008 that dealt with the Second Amendment. And they didn't say anybody can have a gun.
They said quite the opposite. They said we limit these types of things all the time.
Right. It's subject to reasonable restrictions. They said the same thing in Roe versus Wade.
Yeah, just a quick side note for people who may not know the facts of the Roe v. Wade case, because the facts of these specific cases get lost a lot of time in the shuffle, and it's good to have a real-world kind of practical viewpoint of what's going on. So there's a Texas law back in the 1970s. I think it's actually in the 1960s is the relevant time period. And the Texas law makes it illegal completely, flat, across the board, except for life-saving procedures. So if it would save the life of the woman to have the abortion, well, that's going to be allowed. But notably didn't make any exceptions whatsoever for rape victims or incest victims or anything like that going on, minors, anything like that. No exceptions, banned abortion all the way across the board except for life-saving procedures. So the plaintiff in the case, Norma McCorvey, gets her third pregnancy in 1969.
Otherwise known as Roe in the case.
Right, well, yes, correct. Yes, she was Jane Roe.
Yes.
Is how they mentioned her. She then sues the local DA Henry Wade, and so that's why the case is Roe v. Wade. So the question is this Texas abortion law unconstitutional? She wins at the district court initially. State of Texas says we're not done with this fight. Appeal it up to the United States Supreme Court, and that's how it gets to the top.
Yeah, and then the court goes through what you might call a bit of a twisted analysis, right? They don't agree where this right to privacy comes from. They don't agree how the right to abortion, where it's found in the Constitution. There's lots of controversy. They mentioned maybe the First Amendment, maybe the Fourth, the Fifth.
I have them all listed
the Ninth, the 14th.
4th, 5th, 9th, and 14th Amendments.
Now, let me just pause. I like that they commented on the Ninth, right?
Because nobody ever talks about the Ninth.
I like the Ninth Amendment. There's lots of rights I would find in the Ninth Amendment that you could find in the Ninth Amendment.
In preparing for this video, I just did a fresh search on the Ninth Amendment, and there still has been no court in the land that have extrapolated.
This was pretty close, right? They were pretty close to saying in the Ninth Amendment there's a right to abortion. But, of course, this opens Pandora's box, right? There could be a right to smoke weed. There could be who knows what other rights.
Could be dangerous.
Could be dangerous, right? It could have lots of rights.
In the best way
in
possible.
So most of the justices, I think, center around this sort of the due process clause of the 14th Amendment. Well, somehow in there's a right to privacy, and that right to privacy gets us a right to abortion. And by the way, we're going to just create a new trimester scheme.
Here it is. We made it up, and this is how we're going to scrutinize abortion laws. We're going to create something called the trimester scheme, and in that first trimester, states are not allowed in any way, shape, or form to regulate abortions. In the second trimester, they're allowed to do reasonable restrictions on abortion, but they're not allowed to do any undue burdens on abortion. Of course, the court is completely quiet in this case about what constitutes a reasonable or an unreasonable restriction. They don't tell us what an undue burden is as opposed to a due burden. And then in the final trimester, states may at that point fully regulate abortion. In other words, states are allowed to completely prevent you from getting an abortion in that third trimester.
Yeah, and I think it's important to note, too, out of Roe v. Wade comes this notion that abortion is now a fundamental right. And that's important because we had another mess back in 1937 where the court decided to treat fundamental rights different from all other rights, things like property rights and economic liberties. And basically they said if it's a fundamental right, well then the court is going to afford it strict scrutiny. So before the state or federal government can regulate or sort of carve into this right, the court's going to really look at it and make sure there's a compelling state interest and whatever restriction is narrowly tailored. So they made that decision.
Let's break this down. This is a great point. Let's take a quick detour to break this down in plain English. Okay, so whenever the government passes a law, they're restricting your content in some kind of a way. They're saying you can or can't do something, or they're giving or taking away your ability to engage in some sort of conduct. And so the idea of the court court decision that Mark's talking about that's been the law of the land since the 1930s is if it's just restricting, kind of a right that's not really fundamental, it's not really important right, it's not basic to our freedoms or anything like that, and it's just kind of a right that we have that's less important, we don't afford that too much scrutiny.
Yeah, minimum scrutiny.
We call it minimal scrutiny. They just have to show a compelling reason why we need to pass that
rational
law,
reason,
rational basis test.
Low level.
So, for example, if I like to bicycle in the park, and they say, hey, we've gotten people hit in the walking path by people on bicycles, and we want the walking path to feel comfortable, so we're going to put a ban or a restriction on bicycles, riding your bicycle on the walking paths in the park. We would say, all right, they're restricting conduct, but this is a rational basis test. If they have a good reason for doing it.
Question one is, are they infringing on a fundamental right, which you could argue. You could say, well, I have a
fundamental right to ride my bicycle in the park, and you may make an argument for that.
If it's a fundamental right, then the court is going to really look at it. If it's just a lower level, an economic right, a property right, then they're going to give it minimum scrutiny. Now, I think this is a huge mistake. I think we're still saddled with this huge mistake since 1937. For those who are interested, it's West Coast Hotel versus Parrish. I think this was the worst case ever decided in the history of our country. It's the one I would change if I could.
Tell us how you really feel.
Yeah.
You want to talk about strict scrutiny standard, though?
Yeah. I mean, if it's a fundamental right, then like free speech, or now as we're talking here, abortion, or the right to free exercise of religion or something like that, well then, if the state or federal government wants to impinge on that right, the court's going to look at it and say, look, I mean, is this really necessary? Or is what the Congress claiming, is that true? And however they're restricting it to accomplish this goal, is it the least restrictive means possible?
So in other words, if it's getting a strict scrutiny test, the court's really, really going to be critical about it, right? And this makes sense. We don't want the law restricting fundamental rights that we have unless there's a really, really darn good reason, and unless it's really specifically narrowly tailored to do that.
Yeah, and the net effect of this is, if it's a fundamental right, it's reasonably well protected. And if it's a property right or an economic liberty, which, by the way, every right can be construed as a property right,
sure,
then it's not well protected, and the government gets to do whatever it wants to impinge. So in this case, in Roe v. Wade in 73, the court decides, okay, this right to abort, there is a right to abortion, it is constitutionally protected, it is a fundamental right, strict scrutiny applies.
Yeah, and we derive that right to abortion from a right to privacy, which is deeply rooted in our country's history, and here's about 9 different amendments and reasons why we've kind of got that. Okay.
So then we get to 1992.
Right, and before we get to Planned Parenthood v. Casey, I think it's a good time here to take a pause and talk about why immediately a lot of people were very, very, very critical of Roe v. Wade. Not only folks who were in the life camp, but people, genuine scholars on both sides of the aisle, both sides of the political aisle, who looked at this thing objectively and disagreed with what the judiciary did here. Because as we were talking about earlier, the judiciary has a certain role, or they're supposed to have a certain role here. They're not supposed to tinker and twist and contort and get to the decision that they want. They're supposed to coldly and calculatingly, whether they like it or not, whether they like the end result or not, they're supposed to interpret the law, see what the precedent says, and make a decision. And there's some evidence here that has been cited by people on both sides of the aisle that they went way beyond that. They did what we would call judicial activism. They decided to, you know what, we really want to end up that abortion is good. And that's usually done through the legislature passing a law or anything like that. Well, we're going to roll up our sleeves here, and we're going to make up some principles, and we're going to come up with a trimester thing, and we're going to get the end result that we want.
They went far afield. There's no question about it. But they've done this in other areas as well. First Amendment jurisprudence comes to mind. Things like the separation of church and state, where they just came up with the Lemon test, and to decide when something is having what we call excessive entanglement between religion and state action, if you will. And so, look, these can be hard questions. I don't think there's a right answer. The Constitution doesn't say how it should be interpreted, but they went pretty far. I think,
but it's the Roe v. Wade case is a wonderful illustration that it's not what the law says, it's what the guy and gal in the black robe says it says, right?
Look, I do a chapter about this in a book I'm writing right now where I talk about the critical importance of interpretation, because if you put a different 9 up there, you can get a completely different result. There's no question.
Yeah, absolutely. Let's fast forward to the distant future of 1992. What happens in 1992, Mark?
We get Planned Parenthood case, and they make some changes here. They find that, yep, there is this fundamental constitutional right to an abortion. They confirm that. We call that stare decisis. Now they've cited the Roe versus Wade case with approval, and they've said, yep, there is this. But this trimester thing really isn't working out so well. And so they get rid of that, and then they replace it with what you might call a viability standard. Because, look, the point at which an unborn baby can be kept alive outside the mother's womb is a moving target. And they recognize this trimester thing is not workable. They basically get rid of the concept that abortion is a fundamental right, and they throw that out the window. Instead, they say, well, it's something different. It's called a protected liberty interest. What the heck is that? It doesn't require strict scrutiny anymore. There's a new standard in town, and we're saying, well, yes, people can have it. States can regulate the right to abortion so long as whatever regulation is imposed is not a, quote, undue burden, whatever that means.
Yeah, they didn't tell us what an undue burden is or what a due burden is and when the states are allowed to impose a burden and what type of a burden. But a lot of cases that came out of this where there were some laws where there was, I guess we could call it de facto abortion bans, where certain states were trying to pass laws not to repeal abortions because, of course, Roe v. Wade and Planned Parenthood case made it so that that's the law of the land, but essentially making it almost impossible to get an abortion, right?
Yeah.
Putting all these restrictions on clinics and all kinds of things. The hallway's too small.
We see the same thing.
Regulatory laws prevent it from being open. And
we see the same thing all the time with Second Amendment rights, right? Sure, you can have a right to keep and bear arms, but you got to jump through this hoop and that hoop and the next hoop. And, at some point the court says, as they did in Heller, look, you're restricting the right. There is a right. It has restrictions, but it's got limits on what restrictions are reasonable and what restrictions are unreasonable. Same thing we deal with even in the First Amendment context. Then we get to the decision that has not been released yet.
And that is not the official decision. And
that's
right.
right.
We have... It's authentic, and we have reason to believe that it's probably going to be something pretty close to this, but it's not quite the final decision.
Yeah, and I don't think anybody should be surprised here, right? I mean, as they say, elections have consequences. Nobody has hidden that the right has for years been very insistent on wanting to get Roe v. Wade overturned, and those are exactly the kinds of justices that were put up.
Great point, and right now I want to defend some people that I kind of poked fun at a little bit earlier, the people who are saying yay abortion or boo abortion right now rather than focusing on what the actual legal analysis by the court was done and whether Roe v. Wade was properly decided and whether the justices are doing their jobs. The reason why people are rightly concerned and not really as interested as perhaps they should be in that kind of analysis is because they have the very legitimate concern that the justices on the Supreme Court, one or all or some, might just be political hacks that are put in place by a certain party and pretty consistently and reliably vote right down the party lines on each and every one of these
we
issues.
saw this in Bush v. Gore, right? Justices and judges are human, and I think it's probably too much to expect that they could be completely unbiased in all areas. We all come with our life experiences. We all have that, how we think. And so I think it's a bit unfair to say, well, they have some bias. Of course they have some bias. We should expect that. They were selected. I think it's fair to say they were selected because of their biases.
No question.
Yeah.
So let's get to what Justice Alito says in the ruling.
Justice Alito doesn't make any bones about it. I didn't put the exact quote here, but basically he says this Roe v. Wade decision was a disaster from the very
what
beginning.
he used, I think the language, egregiously decided from the start.
Right, yeah. And he, I think he goes through again, we're not putting our personal opinions here, But he certainly had a reasoned legal analysis in that draft opinion. There's no question, whether you agree or disagree, this wasn't just something completely out of left field. He points out, look, there is no right to privacy in the Constitution. They never narrowed down in Roe where they said they got the right to abortion from. It is not something that's firmly rooted. There were laws against abortion for most of our country's history.
It was homicide and everything like that to have an abortion. And he goes through all the country's history and the development of these types of laws in order to refute the assertion in Roe v. Wade that it's deeply rooted in the country's history to have these types of laws. He even goes back to British common law to show that that's nonsense.
You know what bugged me more than anything about this opinion? He dinged my favorite decision, the Lochner decision.
Oh.
Yeah, and just so people know, Lochner's I think I wrote it down, 1905 case. And this is an issue where immigrants who were bakers are coming to town and they're starting bakeries and they're working hard. They are outworking the people who are here. In this case, it was German bakers. They were working many, many hours, even sleeping at the bakery. There was no issue with turning out bad cupcakes or anything. But one group of people didn't like them working so hard, so they said, look, we got to have a maximum number of hours that bakers can work, of course, for the health and safety of people who are buying bakery goods. And so they restricted the number of hours bakers could work, and of course this became a challenge, went up to the Supreme Court, and the Lochner court said, this is BS. We don't care about it. We know you're saying that this has some connection to the health, welfare, safety of people in terms of baked goods, but we don't buy it. There's no way that the state can justify this restriction, and we're using something called substantive due process. In other words, before we take away your rights, you got a due process right for the court to actually do their job and look at the legislation and strike it down. It's not judicial activism. It's doing what they're supposed to do. And then this is otherwise known as the Lochner era court. It's the rule of what we call substantive due process, where the court looked at every restriction on liberty, and if it wasn't justified,
they shoot it down.
It came into existence as a presumption of liberty. There was a presumption of liberty, and any infringement on liberty was presumed to be unconstitutional unless it was justified. And so that's what Lochner was about, and I didn't like how Alito kind of dissed the Lochner-era court.
He called it judicial activism. He called it the same type of kind of tinkering and twisting and contorting that he is accusing the Roe v. Wade.
And he's totally wrong here. The court acting in a negative capacity to invalidate infringements on liberty is not judicial activism.
Totally different than creating a new right or interpreting it to give another rule or right.
So that made me cranky about Alito's opinion right there.
Understanding. But I think that I agree with him on the historical analysis, and I think I agree with the ultimate conclusion of Roe v. Wade. Once again, this has nothing to do with either of our opinion on abortion, whether we're yay abortion or boo abortion. In fact, somebody who's yay abortion should want it to come from a legislature or law or some sort of a process like that. And the reason is this whole judicial activism thing. If you embrace judicial activists and say, I think that the courts, if there's enough of them and they outnumber them, they should twist and contort and basically make whatever rules they want and twist and contort it to make it come out the way that we want it to come. The problem with that is when the other party gets power and outnumbers you.
Yeah.
And if you take that position, you're just going to constantly be in a war of all against all, trying to impose our morality on others.
Yeah, and if this decision holds up, and I expect it will, that's what we're looking at. And to be fair about it, this does not outlaw abortion. What this decision says, and Alito doesn't put his personal opinion in there either, and neither do these other justices.
Right.
What they're saying is there isn't a constitutionally protected right to privacy. There never was. There's certainly never a right to abortion. There never was. It's not firmly rooted. Maybe the right to privacy looked like, to me like in that decision, they're trying to say, well, maybe we can salvage the right to privacy, which I certainly hope they do, because there are many other rights that are grounded in that right to privacy.
Tons of rights
that we want to keep.
Extrapolated.
And so to be fair, right, if you could you're going to be consistent here, you might say, look, the right to marry someone of a different race is protected under this privacy right. Same-sex couples actually having sex. When I was in law school, we had Bowers versus Hardwick,
Right.
which made it illegal to have gay sex.
And the Loving case, not until Loving v. Virginia, it was illegal for interracial marriage.
Right. And so these things all come from the right to privacy. So if you really want to pitch the right to privacy, you are in danger.
Numerous educational rulings talking about parenting and parents' rights. These all derive from that right to privacy that was created by the court.
Right. And so what they're saying with this opinion is, look, we don't know. It's certainly not constitutionally protected. Put it in the place where it's supposed to be in a democracy, which is let the people decide, let the states decide. The state could certainly pass a law or amend their constitution to say there is a fundamental constitutional right to an abortion, and that would be the law of the land in that state. There's nothing about this decision that says a state can't pass a law to say abortion shall be legal.
Yeah, these concerns that were raised by Joe Biden that, okay, well, now that this has happened, there's a whole lot of other things that are rooted in this long established, at least since the 70s, right to privacy that was created that we're concerned about. We're concerned about birth control now. We're concerned about same-sex marriage. And to be fair to Joe Biden, that is an absolutely legitimate concern for people who are proponents of those things, and they need to be rooted. If they're rooted in this now, they need to find a new foundation if they're to survive.
This is why, we're dealing with a mishmash of stuff here with the Constitution. This thing is not an internally consistent document. It's not easy to interpret. People say, well, it just need to get back to the true meaning of the Constitution. There is no such thing as the true meaning of the Constitution.
I think we've illustrated that pretty clearly here. It sounds like if you haven't guessed yet, if you haven't figured it out, in each and every one of these cases where they're just kind of making new rules and new laws and different levels of scrutiny and everything, you might start to get the feeling that they're just making a lot of this stuff up as they go along.
Well, and the same is true for the people who are arguing this, right? The people who say, my body, my choice. Oh, okay. Do you feel that way about illegal drugs? Do you take the position that the drug war should be ended as to all drugs? Because, after all, it's your body, your choice.
How about engaging in prostitution or sex work, something like that? How about engaging in gambling?
Assisted suicide? If it's your body, your choice. What about masks? What about forced vaccinations? Much of the crowd saying, my body, my choice, is also saying everybody needs to be vaccinated. Everybody's got to wear a mask. And so, look, there's hypocrisy and inconsistency all over the place here.
No question.
And I think what we're trying to do, at least, let me back up and say, I think what was the attempt here at having a constitution was to have a rule of law that would be consistent here. Again, I don't think it succeeded for various reasons, but I think that what we didn't want was just a war of all against all. And I think, unfortunately, I think a lot of people are viewing this decision with, I don't care what their reasoning was, as long as they get to what my personal position is, I'm happy.
Yeah, and see, that's a really, really dangerous position for the reasons that we've illustrated. And if you are on one side or the other of an issue, you shouldn't want whether or not the court is going to be activist and come out and twist and contort and come out on your team's side to be the rule here, because then we're just going to constantly be struggling in a war of all against all, trying to impose our morality on other people.
Yeah, and to be fair, I think abortion is one of those questions that it's a hard question. We should recognize this. This is not an easy question, and reasonable people have different views. The question here at the root of this is, when is an unborn baby afforded the same protections as a born baby? Really is the question. When is a baby a human? When is a baby to be protected under, or an unborn baby to be protected under our laws? One group, you might call them the pro-life group, they say, look, from the moment of conception, and they have arguments, right? That you have to have a separate DNA here. 6 weeks, you got a heartbeat going on. 8 weeks, the baby's moving inside the womb. 10 weeks, you got vital organs forming. 12 weeks, you got a human form that's occurring. What else is this but a human being, and it should be protected the same way? The other group is saying, look, we recognize at some point you afford protection. We just don't think right at the beginning is that point, because there are many other reasons, right? The baby is not. There are many things we care about with life. We care about what we call sentiency. We care about consciousness. We care about ability to feel pain. We care about lots of things. And when you're dealing with a right at the beginning, from the moment of conception, none of those things apply. Later on, They do, but when is the question? Some people say, well, viability maybe is the point, but that's a moving target. And so that's the heart of this issue. At what point do we afford protection as if the unborn baby is a human being? At what point is that? In reasonable minds, we should all be honest about and be more respectful to other people with different views here, because reasonable minds can and do disagree on this issue. At what point? There is no right answer here. It's a policy question.
So let's talk about pragmatic concerns here. There's already people that are forecasting that this is going to affect pregnant women, people who get pregnant over especially the next year or so if the law is passed, in very, very negative ways. The kind of conservative estimates, not in the political sense, but in the kind of statistical sense, is that 90 to 140,000 women in states that currently will have abortion restrictions in them will not be able, because of size of state, poverty, living conditions, 90 to 140,000 will get pregnant and not be able to afford or have the ability to travel to a different jurisdiction to get an abortion, because...
And the group who says that the unborn baby should get the protection, they're cheering
they're thrilled about that.
Yeah.
Okay, that's 90 to 140,000 human beings that have now just been saved as a result of this, right?
That's the argument there. Yeah.
So let's get a little bit idealistic here. Wouldn't it make more sense? So right now we've relegated this decision to the states, and I think that
it looks like that's where we're going.
That looks like where we're going, and I think in a cold, calculated legal analysis, it does look like Roe v. Wade was frankly pulled out of the butts of the justices at the time, and so the rationale behind shooting it down at this point, at least from the draft that we've seen, is just that, right? So now we've relegated it down to people to talk about in their states. The fact that it's now been relegated to the states, there will be certain states, certainly, and we're already starting to see those maps shared on social media, right? The red ones here are the ones that are immediately going to have abortion bans. The blue ones here are the safety zones where you can still travel to those jurisdictions to get your abortions. And here's the ones that aren't quite sure what they want to do and might be passing legislation. But eventually, somebody's going to end up right smack dab in the middle of one of those red markers, and they're going to want to get an abortion. Wouldn't it be better in this situation for the jurisdictions that decided this question to be smaller than the size of a state, like Texas, for example? In fact, what if they were the size of maybe like a county, or maybe even like a city or a town? What do you think of that idea, Mark?
This, to me, is the best solution here. I mean, if we're going to get past, we're never going to all agree on when an unborn baby should be afforded the protections of a full human, if you will. And so we got to get past this issue. And so it sure seems reasonable to me to put, if we're going to put this question, not have a one-size-fits-all solution on either side, which is what Roe v. Wade is doing, right? It's taking away a one-size-fits-all solution and putting it into a lower level. I think it makes more sense to put it into the lowest level possible. Make it easy for people to travel and put market forces, frankly, on the jurisdictions that opt for a rule that people don't like, right? I mean, that's certainly a good resolution to me. I hope we get there someday.
Like here in Arizona, for example, a lot of people are freaking out about this and saying the transaction cost is just going to be way too high for people maybe in the middle of the state, in the Phoenix area. If they were to get pregnant and we had laws that disallowed them to, they'd have to drive and get the funds to go to something like California or something like that. They wouldn't nearly be as worried about it if it was the city of Gilbert that decided to ban abortion, and then 12 minutes over in the city of Chandler, they still allowed it, and Mesa didn't allow it, and Tempe did allow it, and the transaction costs at that point would not be causing this panic.
It sure seems to me when if you hit a question where reasonable people are on both sides and they're in disagreement, put this thing at the lowest level possible. You know, I think it's also interesting, and we should note that on the day that we record this video here, there was this Women's Health Protection Act, which was an effort to pass a law now to sort of enshrine a right to an abortion, and that got voted down just yesterday at the time we record this.
Right.
I think it's interesting as well because no one, probably but us, will pause to say, where does the federal government get such a right to make such a law? I mean, remember Article 1, Section 8 at the beginning?
Here's what the federal government can do, and then it lists them.
I didn't see anything in there about making decisions about abortion
policy. This doesn't have to do with coining money or running the post office.
But you know what they're going to say, right? This will go on the Interstate Commerce Clause.
Yes, that's precisely what.
And it will be upheld. And this is another problem, right? I mean, we have what I would call a bastardization of the Commerce Clause that basically allows the federal government to do whatever they want to do. And even though this was voted down, I doubt anybody paused and said, what authority does the federal government have to make a one-size-fits-all rule?
Interestingly, too, and just keep this in mind, I'd be interested to see if something like this happens. Under the ruling, assuming that it's going to go out as something consistent with the draft and it relegates this to the states, there's nothing that I can think of that would stop the states from passing a law that relegates it down even further to lower jurisdictions. Here in the state of Arizona, for example, we could pass a bill that says counties get to decide on a county-by-county basis. Cities get to decide. Municipalities.
Yeah, and under the current state of the law, it may be possible for the federal government to even do that and pass a law based on interstate commerce.
On the Commerce Clause.
To say, you know what? The federal government has decided that a federal law mandates that the decision on abortion must go in the lowest jurisdiction possible.
Yeah, that would be really interesting. Probably the best move. I think that would be great. There wouldn't be nearly as much concern about it, and the market would take care of the side on this issue that has the bad idea. The market would easily sort that issue out, and people who lived in jurisdictions that they disagreed with the position, the transaction costs to go and have it in their way and how they want to could be just a very, very low transaction cost. Seems smart to me. My
prediction here, it's well over 70% of the American people generally support some form of an abortion rights, not an absolute ban.
Right.
And I think that's going to settle out. And I think what we're going to find is the vast majority of states at the end of the day are going to allow abortion in some way, shape, or form. They'll have different rules on this. And I suspect very few states are going to outlaw abortion in most cases. This would be far better off in the lower jurisdictions than in the states. But I think life is going to go on. And, the other thing about this is science keeps marching. Mm-hmm. And so that point of viability gets earlier and earlier and earlier. Said another way, our ability to remove the baby from the mom's womb and keep that baby alive and healthy, maybe to adopt out, wouldn't this solve the whole problem? I mean, to whatever extent a pregnant mom has a right to get rid of the baby from her womb, that doesn't extend to killing the baby, in my view. And so if there is a way, and I think there is, to remove unborn babies, and we're getting better and better at doing it earlier and earlier, and then taking that baby and keeping that baby alive and putting that baby out for adoption, I would call this a win-win-win. And I think that science at the end of the day and technology is ultimately going to reduce this issue to a place where we can satisfy both sides. The pregnant mom doesn't have to be pregnant anymore, and the people who say, you know what, this is a real baby and it should be afforded the right to actually live and grow up. I think we'll be able to put adoptive parents together with that technology. And this issue, we're going to look back at this issue in 50 years and say this is not an issue anymore.
This was correctly predicted, by the way, by the dissenting opinion in Roe v. Wade. They said, this whole trimester thing right here, this is going to be, if you know anything about science, technology, and health and all this stuff, this is going to be antiquated really, really quick. Science is going to keep marching on. They're going to give us better answers and solutions to this. The dissenting justices were keen enough, even back in the 1970s, to recognize this issue.
So if you're listening to this video and you're very upset about the abortion question, I'm going to urge you to change your focus. Think about the nuclear weapons question. Think about real existential threats. Think about synthetic biology and bad guys who are working on creating bad pandemics. Think about artificial intelligence and how this is going to roll out. We may not be the most intelligent life, if you will, on the planet any longer, and what are the implications of that? These are problems we got to solve in a big way that threaten the very existence of humanity. I'm urging everybody to change your focus from this issue to these other issues, I think that are growing in importance that we really need more attention on.
We shouldn't denigrate at all, however, that the fact that this is the central issue for many, many people. If there's a young woman who gets pregnant with an unwanted pregnancy, who lives in poverty, smack dab in the middle of the red state of Texas, and is unable to get to a different jurisdiction,
there'll be a charity.
She's not thinking about artificial intelligence threats or synthetic biology.
She's going to make a call to a charity that's going to fund a van to come pick her up and drive her to a place where she can get her abortion.
That's going to happen. And what I think is that I think that people who are upset about this ruling are about to be pleasantly surprised, because I think that the marketplace is about to ferret out a bunch of old, antiquated, stupid ideas that haven't worked and that aren't consistent with public opinion. And the more that we don't make these one-size-fits-all rules and put them to as small of jurisdictions as feasibly possible, the more we're going to see market forces at work.
Let's keep in mind, we're all brothers and sisters here. Reasonable people see this issue differently. We don't have to divide off and be at each other's throats over this issue. We can get past it.
My final thought is, we've illustrated right now about so many other rights that are tied to this right to privacy that they created in Griswold and reinforced in Roe, and how if we get rid of these, then there might be other rights that are tied to it. Can you imagine if they decided that the Commerce Clause should not be interpreted to mean that the federal government can get involved in all these things other than just basic interstate commerce? I feel like most federal laws would fall down like dominoes. What do you think?
We get the federal government back to something closer to what our framers of the Constitution intended, a limited federal government.
We've got to do an episode on the Commerce Clause and express our outrage about this.
Yeah, we should definitely do that.
Awesome. Well, great discussion today. Everybody go check out attorneysforfreedom.com. Also, we're going to be doing a podcast on this issue. We have a podcast called the Peace Radicals Podcast. You can learn more about that and the global peace movement that we started. That's right, a global peace movement. Go to liveandletlive.org and see what it's all about. We love talking about this issue in the Live and Let Live context.
Yeah, we got through this whole thing, and nobody knows Andy's personal position, and nobody knows Marc's personal position, and that's exactly the way it should be.
That's how it should be in a cold, calculated legal analysis.
Yep.
All right, my friends, thank you very much, and until next time, take care.
Peace.